Hi everyone, my name's Corrin. I'm a freelance criminal paralegal, and in today's video, I want to talk about the top case law that you should know as a criminal law professional. Listen, when I first entered the criminal law field as a paralegal and I'm reviewing cases and I'm talking with the attorneys, trying to develop a game plan, the attorneys would be throwing out these cases left and right that set precedent about this legal issue and that issue, and we could write a motion for this and do that. I knew how to do legal research, but I did not know what type of cases they were talking about. And it was really difficult for me to get on the same page right away. And I felt so stupid having to tell them I actually haven't heard of this case, but I can look it up and I will notate it for later. So I want to save you some trouble of already knowing some important case law that sets precedent on criminal law cases and how they've defined certain legal issues. The first case that I want to talk about is Carroll versus the United States. If you haven't heard of this case, Carroll v. United States essentially established that officers are able to conduct warrantless searches of vehicles when there's enough probable cause to believe that a crime has been committed, but for whatever reason, the circumstances or time does not allow them to get a search warrant first. So I'll give a little example. This could be during an investigatory stop. I hate saying that word. I'm going to use traffic violation. This could be during a traffic stop. Officer comes up to the car. They see an open liquor bottle in there. Okay, well now the officer has enough probable cause to believe that you were drinking and driving. Another example could be smelling weed in the car. And the reason I bring this up actually is because a lot of jurisdictions are saying that that's no longer enough probable cause to search the car, which I think is long overdue. A whole nother story. But that is another example where they've been able to search the vehicle without a warrant. Another situation that I see a lot too is even if you can't see drugs or substances in the car, a lot of police will use a canine to sniff the vehicle, which would give them enough probable cause then to do a warrantless search. They don't need a warrant. They have enough probable cause from the canine alerting that there's drugs in the car, and then they can go and search. I want to preface another thing too, when I'm going through these cases, is that laws never cut and dry. The answer is always, it depends, right? When I'm going through these examples or when I'm giving the case law, that does not mean that you still cannot challenge it. That does not mean that there's not other cases out there that could still be more applicable to the case that you're working on to help you. So I just want to make that distinction. The second important piece of case law that I think you should know as a criminal law professional that I want to talk about is Terry versus Ohio. And you may have heard this already. In my paralegal program, I had to write a whole memorandum on Terry v. Ohio. I had to analyze a case to determine if the arrest was lawful or not. So I'll get into it. Terry v. Ohio essentially says that officers can arrest an individual without a warrant when they have enough reasonable suspicion to believe that an individual not only committed a crime, but is also armed and dangerous. So I'll give an example of this too. Say police officers are doing their nightly run and they come across some individuals on the corner and they see drugs being exchanged for money, and they also see that individual brandishing a firearm. So in that case, they could have enough reasonable suspicion to believe a crime was committed. They saw the firearm, they're armed, and can arrest them. Another example could be they're seeing a robbery in progress and seeing some type of weapons being used for the robbery. Again, these are just examples. I'm not an attorney. I can't tell you that this is 100% cut and dry. I'm just trying to give some context about what legal issues could come up with certain examples. Another case that I want to talk about is Mapp versus Ohio. Ohio, I guess, has had a lot of issues that they have distinguished. But anyway, Mapp versus Ohio says that the prosecution cannot use evidence in their criminal case that was obtained illegally by law enforcement. Another way to say this is if police conducted a search or a seizure that's deemed unreasonable under the Fourth Amendment, they can't use that evidence in court. It's going to be suppressed. So this could be a search of someone's car, of their person, of their house. It just depends on the circumstances. And I, at least as a freelance criminal paralegal, I deal a lot with trying to develop legal issues surrounding search warrants. Search warrants are a big point of contention. Searches in general, seizures in general are a big point of contention that tends to get argued in criminal cases. Continuing on the path or theme of search warrants, the fourth case that I want to talk about is Frank versus Delaware. This is a little bit of a tricky one. Frank versus Delaware talks about how The defense can request an evidentiary hearing if they believe a search warrant obtained did not have enough probable cause. And when you're evaluating that and arguing that, Franks v. Delaware states that it's not enough that the officer made an error or a misstatement. The defense needs to prove that the police officer maliciously tried to deceive the magistrate that was going to sign the search warrant, or that they were intentionally providing false information to deceive the magistrate. And that's not easy. So the only example I can think of this is if an officer repeatedly lies in their affidavit or search warrant, and the defense can prove that they knew the information that they were lying about. Again, super, super tough. I wish I had more case law or examples for this, but it is important to know because, again, search warrants, seizures, big point of contention in criminal cases that you want to argue and fight with and develop. And the fifth, last, most important case, in my opinion, that you should know as a criminal law professional is Miranda versus Arizona. You've probably already heard this case. It's in a bunch of movies. It's in CSI. It's in, I don't know, I don't watch TV, whatever other police movies are out there. Miranda versus Arizona. You've heard of your Miranda rights. That's something that the police are required to read to you upon being in there in custody and them starting to question you. Those are the two factors. An individual who is in what's called custodial custody and is being interrogated by police, they need their Miranda rights read before police can speak to them. Now, the caveat with this is that what's considered custodial custody could be different depending on the jurisdiction you're in. I know that there's been case law establishing if you're at a police department and police are questioning you, say they transfer you to the police department, you need to be read your Miranda rights. If they detain you at a traffic stop, you can't leave. You're in custody, you're in custodial custody, they need to read you your Miranda rights. If you don't know what those are, if you haven't watched enough body-worn camera footage as I have, your Miranda rights are, you have the right to remain silent, everything you can and say will be used against you, you have a right to an attorney, if you cannot afford an attorney, one will be appointed to you by a court of law. Do you understand the rights that I've read to you? They say yes. Officers ask, with these rights in mind, do you wish to speak to me? I'm not even going to give legal advice on that. I'm not an attorney. I have so much I want to say on this point. But this is a big one because what's considered an interrogation could be different. So I really recommend looking at other pieces of case law that may have distinguished those broad terms wherever your case is stemming from. So those are the most important cases I believe that a criminal law professional should know. If you have these cases in your arsenal, if you've read them, if you're able to look at similar cases in your jurisdiction or for your case, you're already going to be steps ahead than I was, at least. Anyway, thank you so much for watching. If you like this video, feel free to like, subscribe, comment, let us know what other information you're interested in learning. My name is Corrin, owner of Lucid Legal Support, and we hope to see you in the next video.